law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been designed to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to protect yourself, your family, and your business. We provide information and resources that will help you decide whether or not you need or want to contact an outside counsel. And if you do, you'll be better prepared, and hopefully so will they. The goal, of course, is for you to receive the optimal results. You'll be better prepared, they'll be better prepared, and hopefully you'll save time, money, and achieve those better results. We want to welcome, once again, from the Bazar Grasso Law Firm, both David Bazar and our special guest today, Nancy Neese.
Thank you.
Thank you. Their law offices are located in East Providence, and we're very happy that they continue to lend their insights and their perspectives on the topics that we cover. And today, a hot topic, a hotly debated topic, and that is the death penalty. It's headlining national news, and it's right here in our backyard in Massachusetts. Massachusetts is the setting for two trials. Recently, very recently, the Dzhokhar Tsarnaev trial was completed, and he was found guilty. But at this point, as of this taping, there's no decision about the penalty. There's a topic of debate about that. Some think it'll be an uphill and tough battle to get the death penalty. Well, he officially did become convicted of 30 crimes. Also on the docket is Hernandez, the ex-Patriots player. As of this taping, he's still on trial, and deliberations continue. There's a debate about whether or not there should be death penalty. Perhaps you have some thoughts about it. Certainly all of the news agencies, print, broadcast, online, they're all discussing capital punishment, whether it's what it should be. Pros and cons we thought we would discuss also today. So David and Nancy, as we begin, before we go through what the current laws are about, maybe a little bit of a philosophical question for you to weigh in on. The very existence of a death penalty in society raises one question, which is about whether or not the justice system is working out of a desire for rehabilitation or out of a desire for retribution. What are your general thoughts about that?
Well, I'll start with that if you want.
Sure.
The criminal justice system, the adult criminal justice system, is both retribution and deterrent for other people who may commit crimes. And if there's a reason to think rehabilitation is part of the process, that's part of the process. But the penalty phase is really retribution and deterrence, as opposed to juvenile cases where it's all about rehabilitation. And that's the whole idea between a distinction of juvenile cases and adult criminal cases.
Good point to weigh in on. Nancy, your thoughts about that?
Well, I agree with David, and I think the death penalty obviously is not aimed at any kind of rehabilitation, but it's only used for the most heinous of crimes, capital crimes. And in fact, you know, I don't know how many states still have the death penalty, but a lot don't. And Massachusetts obviously doesn't have it anymore because it doesn't meet the needs of the kind of a liberal state that they are. I know,
I think it's 1984, as I was checking. No longer does that apply in Massachusetts, but there still are many states that do have the death penalty, and federal, which is Tsarnaev.
This is a federal crime, so that's why it's up for discussion.
So the Supreme Court in 1972, I think it was, said that the death penalty is unconstitutional because there were no guidelines, there were no principles that a jury could go back and debate about, and they were afraid that the deliberations would be based on emotion and other types of input rather than a guideline given to them by a judge. In 1976, it was reinstituted with the notion that a judge could give guidelines as to what a jury needs to think about and deliberate in determining whether or not they want to impose the death penalty.
So before we get into this, with those trials by jury, when they're talking to a would-be jurist, do they actually have to ask them what their feeling is about the death penalty and use that as a factor in considering whether or not they're worthy of serving on that trial, or whether or not both parties want them to serve?
Oh, absolutely. In fact, they, this jury panel is death penalty qualified, I believe they call it. So everybody who's still in the jury pool has agreed and has stated to the judge and to the lawyers that they would be willing to sentence somebody for the death penalty.
And it's interesting because different states have different models. This is a federal trial.
Yes.
Sarnaev. Some states that have death penalty use a bifurcated trial, which is first the jury is impaneled to determine whether or not there's guilt or innocence, and if someone's found guilty, then, and it's a death penalty case, then a second jury is impaneled to determine what the penalty should be, life in prison without parole or the death penalty. And so there's debate back and forth as to which is the better model, because some folks feel, as Nancy has said, now you have to impose in the first instance a jury that has already determined that they would impose the death penalty qualified jury that's going to determine both the guilt and the penalty.
I think it's probably safe to assume that most people in the country today have much more of a cynical approach to considering the death penalty. I mean, obviously there's been so many mistakes. That's, I think, what prompted things like the Innocence Project that we've talked about before. Sometimes they do get it wrong.
Right, and that's why in this particular case with Sarnaev, he's practically admitted that I think he has admitted that he was involved in all of these. So there is no danger in his case that he would be wrongly put to death. But that's assuming that the other qualifications are met and there are not enough other mitigating circumstances.
Right. And that would lead us into a little bit of a discussion of what are all the issues that go into, first of all, a jury deliberating on whether or not to impose the death penalty, and in particular in this type of case we can look at and apply some of those factors to it. And the whole general discussion of death penalty, you know, there are so many other issues other than just what the jury is going to determine in this case. So you tell us where you want us to go.
Well, I was actually thinking that the next thing we should probably talk about some of the pros and cons, and as you were saying, even about this case. So why don't you continue, David?
Okay. So for this particular case, the judge has to instruct the jury, and the jury is going to hear evidence, as Nancy was saying, on aggravating factors. What are the factors that would lead the jury to say that this particular crime rises to the level of a case where the death penalty should be imposed, versus mitigating factors? What are the factors that are particular to this particular defendant that would lead the jury to say that that outweighs the aggravating factors and the death penalty should not be imposed? So I know you've thought quite a bit about some of the mitigating factors in this case.
Right. Well, I guess, you know, first thought is that this is a 21-year-old young man, you know, who is theoretically not thinking quite as an adult, although he's an adult, but he's a young man. And the way the defense has laid out their case, they're kind of laying the groundwork to say that he was influenced by his very domineering brother, and he was really just a follower, which would be a mitigating circumstance. He wasn't the mastermind behind the crime. I mean, that's really probably the biggest factor, and I think that's where the defense is going to probably bring on all their witnesses to show that he really was a follower of his brother.
And to your point, Nancy, or maybe David, you might want to address this, might that be one of the reasons that they would want, at least in this next penalty phase of the trial, to have him on the witness stand, where he might be able to, in his own defense, say, I was a good kid, I don't know, was he captain of a football, not a football, soccer team, wrestling, thank you, David. And I really was under my brother's, I was taking my brother's lead, if not blame him entirely. Is that likely to be an issue?
Yeah.
So that's absolutely a possibility. Nancy and I were talking earlier, and whether or not the lawyer should have put him on the stand in the first instance in determining whether he was guilty or not. And we agreed there was no reason for him to take the stand at that phase, because she was admitting he was guilty. There was nothing for him to say that could be helpful. And frankly, if I were his attorney, I wouldn't want him on the stand at that stage, because you don't know what he's going to say and you have no control over what he might say. So defending him, you wouldn't want him on the stand then. In this phase, in the penalty phase, if I were his attorney, I would really need to know exactly where he was going to go and what he was going to say. And if I were uncomfortable at all with what he might say, that wouldn't be helpful in laying out these mitigating factors, I wouldn't put him on.
And I think in the news, they've repeated that he showed no remorse. He's showing no remorse and hasn't shown any remorse. And that can cut both ways. Do you want to put him on the stand to say that he, was in a trance by his brother and really was just not knowing what he was doing? Or, on the other hand, maybe don't put him on the stand because he has no remorse and, the tone of his voice and the way he's going to answer is not going to be helpful to them.
Does the fact that he made show no remorse, does that weigh in on your particular your personal feelings about death penalty?
Well, I don't think so.
Okay.
But in this particular case, what it would be is, you said in general on the death penalty.
Okay.
In this particular case, there's the aggravating factors, which we didn't talk about yet. So what they're going to look at is, was the crime particularly heinous? And this was absolutely heinous. Was it designed to kill multiple people or injure as many people as possible? It was. Did you kill a young person? Yes, he did. Was a police officer killed? Yes, he was. So all of these aggravating factors piled up against the mitigating factors, that's what the jury now needs to consider. And as they're doing that, I would, if I were a jury member, be looking at this particular defendant's demeanor. If he didn't testify, his reaction to the testimony that was going on. And I would want to weigh and balance whether there was a depraved mind there, if I could determine that as a juror. So if I were a juror, his demeanor and his reactions would very much be on trial, just as much as if he had took the stand and testified.
And not to mention his demeanor at the time of the verdict.
Right.
Absolutely
No
callous,
response.
stoic.
Yeah.
I think that, and as I asked in general, when people see signs of there being no remorse, I think that if they're on the fence, that tends to harden them. I mean, that's a perception. I think that another issue that was not specifically relating to just the time of the case when that happened, when the bombing took place, but there was footage that showed that he was so callous as afterwards to drop into a Whole Foods or something and have a container of milk or something. That's certainly not someone who was distraught or having second thoughts about what a terrible thing. He just went about his business as matter-of-factly. I imagine that too gets to be part of that penalty phase, and they start to see how he behaved even right after the...
I'm actually not sure that would be admissible evidence.
Might not be?
Might not
Good
be.
to bring up. Okay.
But it depends on what is brought up. If, for instance, if he does testify and he starts laying out things that they want to rebut, the prosecution might be able to bring in things like that. But in and of itself, I don't think they could just show the footage and say, look at what he's doing. But it would be interesting. So that also has to weigh in the attorney's decision whether or not to have him testify. My own personal opinion is I don't think you're going to see him testify.
And I would agree.
Nancy, you don't think so either?
And the other part of this, I guess, because this is such a community kind of case involving all of Boston and never mind the whole nation, is the jury's probably going to try to think about what will the death penalty do? Will that put this to bed, or will it just make it worse and make it a terrible ending? David and I have talked about that. Will it really help, or is it better to let him live and maybe have him do something good for society? Or, I think the jury's going to think about all those things, an eye for an eye or not.
And that's part of what goes into the death penalty. So what we were saying is whether it's better for society in general that what would be the worst punishment for him? Does he want to die anyway? Does he want to be a martyr? Are we just playing into what he wants and what other terrorists would grab onto? Or would he suffer more from being in a prison cell that's tiny, solitary confinement, 23 out of 24 hours a day, no communication with the outside world, and just a rotten existence? If that were in fact what would happen, and it's my understanding that that's the facility he might end up in. So you then have to decide, there is, whether or not you're for or against the death penalty, there are other factors that I think this jury might want to consider in what is a worse punishment in this case for this person, and what are the other factors outside, as Nancy was saying, for society. So if the death penalty is designed as a deterrent, and we put him to death, is that a deterrent to other would-be terrorists?
Right. And I think this case is different because it is a terrorism case. It's not an individual single crime of passion. So do the death penalty circumstances really hold true for a terrorist case versus a murder case of a husband murdering a wife, wife murdering a husband, something like that?
Or the murder of a police officer, you know, in the line of duty with a depraved heart and no remorse.
I think it's probably worthwhile to mention that the person who is defending him, who was selected to defend Tsarnaev, is clearly a well-known person who works very hard to make sure that capital punishment isn't the sentence. So I'm not so sure that he wants the death. I'm very certain that he doesn't want the death penalty, although to your point, it may very well be that his life in prison without parole will be its own hell, its own...
Well, some of the factors that go into people not being comfortable with the death penalty really do not apply in this case. We talked a little bit already about whether or not we could potentially be putting someone to death that might not be guilty. Not the case. Clearly. He's admitted his guilt. His lawyers admitted his guilt for him. He did it. There's no question he did it. The other issues that can come up, and I know one of the things that comes up sometimes is how much it costs to put someone to death. Well, you know what? That's not really an issue. If there are appeals along the way and there's all the other costs of doing it, you know what? The fact of the matter is you're putting to death somebody who's 21 years old, who would have to be kept alive for a long, long time. I'm not so sure that in this particular case, one cost is really going to outweigh the other. And really, it shouldn't matter.
And the issue with cost is that it's much more costly to have a death penalty case than it is to have a life in prison sentence. I mean, it's basically half the cost or something like that, 2 to 3 times the cost, just because of the appeals. Things.
Another good point to bring up.
And you know, if it's important, that is one of the points.
And in this particular case, you know, given the terrible, heinous crime that this kid committed, it shouldn't be a factor, I don't think. And I don't think it would be for most people. Sometimes they say that the people who are facing the death penalty don't have good counsel. Well, we know that was not the case at all in this case. He had someone very skilled in these types of cases.
And you mentioned the idea of terrorism versus a single person, which we'll talk about Hernandez in a minute. But when it comes to, was it Moussaoui, who's been on death row or whatever, hasn't had a lethal injection or anything yet, but you can imagine with the number of appeals and what his life is like anyway, as you pointed out earlier, 23 out of perhaps 24 hours a day in solitary, and I'm sure that the inmate population is less than kind and nice to him.
So then the real issue comes down to death penalty arguments in general. There are people who don't believe that the government should be killing people, that it's immoral. And, you know, that's a morality argument. It's not a legal argument. And if people have that feeling, then they should hold on to that because there's something to be said for that. Not to mention the fact that there are other people who think that allowing the government to put someone to death is really a bad thing, especially given that they can't even fix potholes correctly.
That's very often quoted. It's true.
Right, exactly. So the moral issues and all of that, which do weigh into this, really don't apply to the Tsarnaev case, or however you say his name, in the fact that it's the law, and the court has to follow the law, and the jury has to follow the law, and now it really becomes a jury decision based, hopefully, on the guidelines given to them by the judge.
Of course, if you were to think that offering up the death penalty would be the ultimate deterrent, I suppose you could say, well, then no one would ever kill anyone again. And of course, that speaks to perhaps its lack of
just as a general rule, that is, you know, that argument can go either way.
Sure.
It is meant to be a deterrent, but in fact, studies, I guess, have shown, if you read certain studies, that it really doesn't deter any crime at all. And clearly, in this case, it wouldn't be a deterrent because it's a terrorist case.
And now, while it's still being deliberated, the Hernandez trial, where that young man is being accused of being involved with the murder of Mr. Lloyd.
Odin Lloyd,
Yeah.
right.
Yes. So while that's being deliberated, they're even talking about first degree, second degree, and we know that in Massachusetts right now there is no death penalty.
Right.
Yet the conversation's been coming up. What do you think about this?
Well, first of all, it's not a death penalty case. Massachusetts doesn't have it, and the facts of this case wouldn't arise to that level anyway. So I have not been following it as closely as a particular paralegal in our office has been following it. And it's her opinion that he's going to walk, that they're not going to convict him, and I disagree. And I have not followed a lot of it. And I know his lawyer has lawyers have done a very good job and poked a lot of holes in the case. But Massachusetts has a rule, and it's called the joint venture rule. And in this particular case, Hernandez went for a ride with the victim, Odin Lloyd, and the other fellow, Wallace, I think is his last name. And it was the three of them. And his lawyer has to admit, because they have evidence of it, that he was there when they got out of the car and the guy was shot. So I believe under Massachusetts law that that shifts the burden back to the Hernandez camp to show, even though, as we've talked about many times, the burden of proof is on the state. The state has to prove its case beyond reasonable doubt. But when they can show that he was there, that the fellow was killed, and it was the three of them there at the time of the murder, they don't have to prove that he actually pulled the trigger. All they have to prove is that the murder happened while the three of them were there, and that Hernandez went there with the intent of allowing the crime to happen and participated in it. And in this particular case, the facts to me that are most compelling, the fact that the only other person there with him was somebody who's sort of his flunky, I guess you would say. He gives him money, he relies on him for a lot of the things that they do and do together. So there's no way in my mind that a jury can overlook the fact that this other guy would not have killed him if he did it without Hernandez's participation and blessing.
What about the firearm issue? Who owns it and whose possession and whose fingerprints? I mean, if Hernandez owns it, obviously his fingerprints are on it.
But that's a whole different charge. I think that's just
That's
the firearms
another
charge.
charge.
Right. And that's, you know, honestly, I don't even know that much about that issue, but I know that that's a separate charge, and I would imagine that will probably, he'll be convicted of that.
Right.
Minimally.
Yeah.
If he's lucky.
And so a lot of people say, and my paralegals debated this with me, that they don't have the weapon that killed him. And, you know, how can you convict somebody without that? And you can. And that's not a necessary component to the case. And they've talked about motive. And motive is really not a necessary component to a case. It's helpful for a jury to convict somebody to know why something happened, but it's not part of what needs to be proved. So I don't think the fact that they don't have the weapon is detrimental. It's detrimental, but it's not a flaw, a fatal flaw to this case. And I think that my prediction, and I know I'm not supposed to be in the prediction game, that there's going to be a conviction on this case for Hernandez.
First or second?
For murder?
Yeah, I'm not sure
for some kind of
first or
murder.
second, but some. And so the only other piece to that, and I know Nancy can weigh in on this, is that even if he isn't convicted, there are other things he's facing.
Right. He's facing murder charges, I think, for two other murders in Boston and one other shooting of somebody in Florida. So predictions are that no matter what happens, he's not leaving the prison anytime soon.
What do you think about what's going on with his present case as it's
Again,
being played out?
I haven't followed it as closely to be able to give a prediction, but I would probably say that it sounds like maybe, if he's going to be convicted of something, maybe it will be the second degree. But again, that's just a kind of a guess.
I agree
based on what what I've heard.
When you mentioned earlier, David, that motive isn't the only thing that someone considers and isn't a make or break for the case, I had been thinking about that a little bit, and I only hear that there was a dispute and somehow there was some disrespect. We've not heard anything about what was the source of that confab, however that was.
Right.
I think...
Is that going to be explored? Does it need to be explored and fleshed out?
I mean, I don't know that it hasn't been, but I think it was just a disrespect that he was using his name, right? Wasn't it that
Well,
he was touting his name around?
There are a couple of different things along the line. And my point, though, was it doesn't matter.
It's not an element of the crime.
It's not an element of the crime, right? It helps for a jury to understand why a crime was committed and therefore to help convict the person who did it, but it's not an element that the state needs to prove beyond reasonable doubt to get a conviction. So, you know, if the jury is really concerned that they don't have anything but circumstantial evidence and there's nothing directly to tie Hernandez to the murder, they might want to know more about the motive as to why he would have done that, and that's why it's been an issue. But as I said, it's not an element of the crime, so if they find on the joint venture the law that is the law of Massachusetts that says if Hernandez was there and now he participated in it, he now has to show why he was there, how he didn't participate, and how he didn't have any intent for this to happen. And nothing, as far as I can tell, has been shown on that to say that Hernandez had nothing to do with this.
And if you both feel that there's a chance that he's going to be on the guilty side of this, 1 and 2, what's the difference, tell our viewers, what's the difference in terms of the punishment, in terms of imprisonment, parole, no parole?
Yeah. They're both punishable by imprisonment. The length of time is different. The likelihood of parole is different in terms of how much of the sentence you have to carry out and so forth. I am not 100% familiar with the Massachusetts Penal Code, so I can't tell you it's this number of years or that number of years. But given the facts of this case and then the facts of the other issues that he has, I think he'll be on the higher end of a sentence than the lower end. And you know, one of the things my paralegal has told me is that the judge in Massachusetts has really sort of leaned over backwards for the defense on a lot of the rulings. And I kind of think that part of that maybe, and I don't know, I haven't been following it that closely, is she doesn't want to make any mistakes to give Hernandez an appeal that would...
A worthy appeal,
worthy appeal that could reverse any decision that's made.
And we talked earlier about the potential for rehabilitation. You all brought up the idea that there are other charges that are pending elsewhere, other crimes.
Right.
Are they more likely to want to think about him in terms of rehabilitation when they already know that there are other things in the queue that he could be going to trial about?
So,
well, I mean...
Or does it not matter?
I don't know that it matters in this case because, you know, he's going to prison. He's not going to be sentenced to death in any case. So whatever rehabilitation there'll be in prison, you hope for that rehabilitation. So I don't know that that weighs in at all to what the jury would think.
He's a young man, but he's not a juvenile. So it's really not part of the process.
Good to know. We certainly have had plenty to discuss. David, Nancy, thank you so much for being with us. We hope that we've shed a little light on the current hot topic about debate. And stay tuned. I'm sure that we'll be reading lots more about both of the cases. Thank you for watching The Law Matters. Please stay tuned because the law matters to you.